what we're talking about. But it's really negative from your point of view, because we've already got quite a lot of people on, and I have to send the link out. So, Philip, have you got any funny stories that you could tell us? I know you're a man that always has an anecdote up his sleeve.
Well, that's very clever of you, Adam, because that just catches me totally on the hoof. The last anecdote I did, all the women found hilarious, and the blokes got annoyed about. So,
Tell us that. I want to know what that is.
Well, it was. I'll have to remember the anecdote. It was all to do with a lady, and she gets a car stopped in Harrogate by a police officer. And so the police officer says, "I'm booking you for speeding." And she says, "Well, can't you just let me off?" And he said, "You must be joking. It's more than my life's worth." So she thinks, "Okay, fine." So she comes up with a cunning plan. So she phones the police herself and gives her own registration number out. Oh, that's right. She tells the police officer who stopped her that, "Look," she said, "to be perfectly honest, I've got more things to worry about. I've got a knife in the boot of the car." So the guy goes, "God, a knife?" And she goes, "Well, actually, I've got a gun as well." "What?" He goes, "Well, I stabbed my husband to death, and I shot his friend, and they're in the boot." This police officer starts panicking like mad. So he says, "Right, I want you to get out of the car, stand against the car." He said, "I'm calling help." He said, "I can't deal with this." So he phones up, and 5 police vehicles arrive. And the woman is standing at the side of the vehicle, and the police officer asks another question. "I'm not speaking to you," she says, "I'm speaking to the most senior officer present." So Chief Inspector steps forward. He said, "Okay, I'll handle this." He said, "Madam, what is the problem?" She said, "It's your officer." He said, "He says I've got a body in the boot." "Well, have you, madam?" "No." "Oh." He's also said, "I've got a knife in the boot." "That's right." "Have you?" "No." "Have you got a gun in the boot?" "No." "Let me have a look." So Chief Inspector runs forward, looks in the boot, says, "No, there's nothing here." So the woman turns around, "And I bet he said I've been speeding as well, hasn't he?"
Well done, Philip. You performed under pressure there. Well done.
Yeah, very under pressure, Adam.
Okay. All right. Look, I'm assuming now that my out of office now has stepped in and is now handling this for me. I hope. Otherwise, this is very frustrating. I'll just let me verify that it's on. Yes, it's on. And it's on. Perfect. Hopefully that's working now. Okay, guys. Whew. Hopefully, disaster averted. If not, we're going to send out this as an email to everybody anyway. So don't worry so much. So let's get cracking. Now, like I said right a moment ago, for those of you who've just joined, we had a slight technical difficulty, so we're a few minutes delayed. Now, this is important, but I want to just quickly say, we are just 3 blokes, okay? So obviously Force 24's got a vested interest. Obviously Paul and Philip have both got a professional interest in what's going on, but we're just blokes. And what this is a chat, and it's designed for us to talk around the topics that we are observing at the moment. So these are real life topics. They're really important and quite scary, but we are just 3 blokes. So if our delivery of the message is a little bit shaky, please don't shoot us, please don't hate us. It's good content, but just bear in mind that this is just 3 blokes talking. So first things first. Now, I'll give a very quick intro. Philip will give a quick intro. Paul will give a quick intro, and then we're going to get straight into this. So I'm Adam Oldfield. I'm the Managing Director of Force 24. Force 24 was founded in 2010. We're a marketing automation platform, and we are based in the UK. So what that means is we don't use Azure, we don't use AWS, and we don't use servers located outside of the UK. So this is one of the most amazing things that could ever happen to Force 24, because it says data sovereignty is now something you need to be worried about. Data sovereignty means you collect some data in this country. Where you send that data is a problem. Where should I send it? Should I send it to North America? Should I send it to Somalia? Where should I send it? We keep data within the UK, so that's big. So I'm the host today, so I've got no specialist knowledge in the law that's behind this, but I have a very, very keen eye on conspiracies. So I like to always think about what's actually China got in this to do with this. What's the USA got to do with it? But anyway, that's by the by. So Philip, would you mind giving us a quick intro, and then we'll do Paul?
Yep, sure. So I'm Philip Allett, Managing Director, Allett and Associates. I'm also the Force 24 Data Protection Officer. I have a law degree. The company I work for does a number of things, one of which is data protections. And I advise companies, not just in the UK, but also overseas in Australia, America, etc.
Perfect. Thank you, Philip. Paul, would you like to give us a quick intro?
Yeah, sure. So I head up Berwyn's Digital, which is a specialist digital division of Berwyn Solicitors. We're based, our team is based in Leeds, and we advise technology businesses, particularly in all sorts of technology related matters. So that is data protection, contracts, intellectual property, software, open source issues, and on all kinds of things relating to that. So really specializing in this area.
Okay, so we've got the right guys to talk about this, I hope. Absolutely. So those of you that were that attended our first webinar 2 weeks ago about this subject, we were sort of, everybody was finding their feet a little bit. And what we're going to do in this webinar is we're going to very quickly catch up for those that didn't attend the last one and talk about what is the Privacy Shield, where it came about, what's going on, and then we're going to talk about what the situation is for each of you out there. So Philip, would you mind giving us a little bit of a background as to why we have the Privacy Shield, and what exactly, what is it? What is data protection? Where did it come from? Tell me about that.
Okay, so without getting into too much detail, 1945, most of Europe had been occupied and run as totalitarian states. English lawyers, of course, England or United Kingdom hadn't been occupied, got together and decided that they should put together some articles of human rights, and they did the first, I believe, 8 clauses. Last one being Article 8, the right to privacy. The right to privacy has been developed since 1945. Incidentally, this is nothing to do with the European Union. This is the European Convention of Human Rights. Hague, think of the Hague, think of a completely separate court system. So the European Union came into being, and the European Union has continued to develop for member states data protection. Of course, the United Kingdom joined in the 70s, and some of you will be familiar with the Data Protection Act, and of course the Data Protection Act in a 2018 format still exists. However, in May 2018, GDPR came out. One of the things that is enshrined in law in the United Kingdom and elsewhere in Europe is the right to not just privacy, but the right that your communications is private to you, its personal identifiable information should be protected. America, think now, America 1945, the main victim, one would argue, of the Second World War, never been occupied, totally different view. The state is everything. The state won the war. The federal government is supreme. Therefore, we don't have the regulation that we have in Europe. So in the United Kingdom, we have the Information Commissioner's Office. That is replicated in Dublin, in Paris, Germany, etc. It doesn't happen in America. They have no concept in terms of data privacy, with the exception of the state of California, which has got its own law. And that's the problem with the states. So the America sees this kind of scenario very much down to the states to deal with. So there's no department responsible, no federal department responsible. So Department of Commerce handles something called did handle something called the Privacy Shield.
Right, Philip, do you know what? This is why I love you. We start, I said, give us some background. You went right the way back to the Second World War. Love it. Absolutely brilliant. But no, this interesting point that you make, though, it is that, no, I didn't know that. I didn't know that there is a difference. We fought against other countries, and there was a reason why that was created. And there's a reason why Europe, the UK, are fundamentally different to North America. Okay, so I didn't realize that, but then that turns out that that's what it is. So we ended up in 2016, I think it was, with Privacy Shield being the legal framework that enabled you, as you guys at home, to be able to transfer data out of the UK to North America? Because as I said before, data sovereignty. Paul, do you want to tell us what data sovereignty is?
Yeah, it's to do with who actually owns the information, personal information, and within Europe, the very strong narrative is your personal data belongs to you, doesn't belong to the state, it belongs to you, and we're used to, for instance, it being said about China or about Russia that their personal data belongs to the state. But that applies also to a large extent to the United States as well, and that is why this is a real issue. Privacy Shield actually replaced something called Safe Harbor, which was also struck down as being invalid, and then Privacy Shield, that's also been struck down as being invalid because there is a fundamental difference between the way the different countries view personal data. So
Paul, I'm going to drill down into that particular point very, very soon, because I think that is the problem. There is a fundamental, these frameworks or policies, however you want to call them, they come, they go, they come, they go. And we have a proven history now with Safe Harbor 2016, with Privacy Shield 2020. Whatever comes next it will have a lifespan of 3 or 4 years, because we know that's how long it takes to run through the European Court of Justice. That's just how long it takes. And so whatever comes, it's going to be attacked. And we're going to come on to the fundamentals as to why it's going to get attacked shortly. So, okay, we understand now that we have a reason for it. So what I'd like to do is, if we wouldn't mind, I would like to talk now. Philip, can you give me, why is it okay for us to send data to, say, Europe? Can we talk about that? So I'm in the UK right now. What is the difference between the UK, me sending data to the UK, Europe, say France, then what's the difference between me sending data to, say, North America? Then what's the difference between me sending data to Botswana, picking anywhere? What's the difference? Why is there a difference?
So the European Commission decides something called adequacy. It's taken as granted that anybody who is a member state of the EU meets adequacy. There was also a decision made that the EEA, which is the wider area, includes Norway, Switzerland, etc., that they had to meet adequacy to be part of the EEA. A bit of fudging went on, but that's fine. Elsewhere, the European Commission actually do a series of tests to see whether a country meets adequacy or not. Unfortunately, sometimes these can, it's done by the Commission, it's a Commission ruling, and it's binding on member states. However, there's a big question as to some of the places they've actually decided meets adequacy. So Uruguay meets adequacy. Australia does not meet adequacy. The United States does not meet adequacy. And the European Court of Justice has actually ruled and said, in certain circumstances, it can never meet adequacy under its current structure. So there's some fundamental difference. So countries outside the European Union have to meet something called adequacy. There is a handful of countries that do that. Canada does in North America. Obviously, America doesn't. Israel does. New Zealand does. But as I said, Australia doesn't.
So let's talk about adequacy, because okay, so I'm a layperson and I'm thinking, right, well, I kind of get it if you say China. Okay, so sending data from the UK, I've collected your name, Philip, and your email address, or I've just collected your email address, whatever. Collected that from a website, and I'm now going to load that into a platform in China. Now, I get that China is like, it works totally differently, but I kind of thought North America and Australia fundamentally were pretty much the same as us, and then turns out they're not. So adequacy, okay, that's been ruled they aren't adequate. What sort of things make it adequate or not adequate?
Okay, so the first thing is that there's an independent arbitration system, and then thereafter there's a legal recourse that and remember this only applies to European subjects, so European subjects and at the moment UK subjects can actually appeal against. Now, in America, that framework didn't exist, so it was created, and this was the problem, it was created with Safe Harbor and subsequently the Privacy Shield or Privacy Shield to give people that level of protection. But in effect, if it's sort of in Uruguay, for example, or Israel, or some of these other places that's got it, there is a legal framework, people have got legal rights, and that's enshrined into that country's law. And of course, these things take a long time because legislation has to be done, and then the European Union has to look at that legislation and be satisfied it meets requirements.
Absolutely. And I heard this, as I said right at the beginning, I do love a conspiracy. And one of the things that you might have heard of the Patriots Act. Philip, I know we spoke about this on the last webinar, and I think it's quite an interesting point. You know, the Patriots Act was post 9/11. North America, obviously, you know, they got hit by probably a very, well, the most considerable terrorist attack that the world had ever seen. And that forced a change in legislation. And I think, personally, this is probably one of the things that totally flies in the face of, you know, data protection. So the Patriots Act came out in 2001, and it basically said, and you could probably tell me if I'm saying this wrong or what I'm saying in layman's terms, basically said that the government or the federal government or any representative of the federal government has the right, either with or without warrant, I might be wrong here, with or without a warrant, to access any data stored on North American shores, any data. So you think about that. As Paul, you mentioned a moment ago, you said the data belongs to the state. So in Europe, the data belongs to you. You guys out there, it's your data, your name, your data. You decide what happens with your data. And we're kind of a little bit protective of that position, aren't we? You know, we like the fact that I've got a little bit of a say what goes on. But that Patriots Act basically said, yeah, you've kind of got a say, but if I want it, I can have it. And that's right. I'm not just talking a lot of hot air. That's the case, right?
Yeah, yes, but if you think, and Philip's quite right to look at the history, so not just that Europe was occupied, but the people who are most evangelical about privacy are the Germans, because they were center of Nazism, and now they take the completely opposite view. They don't want to go back to there. They don't want to be controlled. They don't want individuals to be controlled. The US never had that experience, and so they start from the point of view of the security of the state is really what matters, and anything else is subsidiary to that.
Yeah, I love that. And I failed to see how, as I said at the beginning, how any framework can ever overcome that position, and that's just how it is. Now, Philip, what you've done is you gave us earlier on, you gave us a list of countries that meet adequacy. I'm going to put that in the chat. Anybody wants to look at it in their own time, please do. I think I can put it in the chat. Can I put it in the chat? Yeah, I can put it in the chat. Okay. Will, thank you, Will. I feel for you. Sorry, I didn't see that. That was when I was wrestling 100 emails coming in a minute. But, crap, the webinar link's not working. Anyway, so I've put in there a list of companies that meet adequacy. Now, let's get to some more meat. We've had the little amuse-bouche. This has been the little introduction to the history. Let's get to the meat. Let's get to why am I here? Why do I care about this? We know that the USA does not meet adequacy rules. We now know that the Privacy Shield, the framework that we relied on to say it's okay to send that EU consumer data to North America, has gone. So if I send data now to, let's say, for argument's sake, MailChimp, sat out in North America, am I breaking the law or am I not breaking the law? Let's take, Philip, your view on that first.
Okay, so it depends exactly what data you're sending, but technically if you're sending anything that's personal identifiable information, and personal identifiable information includes in certain circumstances an email address, so philip.allett@force24.co.uk is a personal piece of identifiable information, and you send that to the States and there isn't some other legal framework that you're working with, then technically you are in data breach. And the issue, Adam, is, and I need to emphasize this, that the onus is on the UK company to check and to make sure it's being compliant. It's not on the likes of MailChimp or any other platform to check that it's been legally compliant. MailChimp and other American companies and elsewhere in the world are not responsible to the EU, but we're based within the EU. Currently, we have to be in sync with Europe, and therefore it is us, or it is the UK company that chooses to transfer that data that is in trouble, not the recipient of it. That really does need emphasising.
Okay, thank you, Philip. Paul, I'd like to ask you the same question. Am I now breaking the law, sending that data out to North America?
Strictly, yes. The EU was, the European Court of Justice was very clear that there wasn't a transition period to allow you to sort these things out. From the moment the judgment was made, then Privacy Shield was no longer valid, and the export of data was therefore no longer legitimate. In practical terms, people can't take immediate steps. It'll take a while for people to sort out what it is they're going to do, but companies do need to address the issue. They can't just say, I really don't care about it.
Yeah, okay. Actually, I'm just going to pause there for a second. So Joe, you just put a question into the chat. What I'd like to do is, please, everybody, as you see something, fire it into the chat or the Q&A, however you want to get it to me, just fire it in and we will pick through them in the end. I just want to get the framework sort of, let's get the words said that we need to say, and then we'll get onto the Q&A, which is going to be the majority of the session. So we'll just be taking specific cases. So thank you for putting that in, Joe. We'll get round to that in a moment. But interestingly, Paul, earlier on, when you were talking about that exact point about the transition period, so somebody on the last webinar said, oh, that there's a transition period. And then I said to you earlier on, so talk to me about this transition period. What did you say?
Yeah, so what happened immediately afterwards was the Information Commissioner's Office, which is the UK regulator, said if you're operating under the Privacy Shield, carry on doing that for the time being. That statement we cannot find, so that's been withdrawn. It's not there anymore, and clearly they took a more detailed reading of what the judgment said. So they're now not saying that. They are saying they're going to take a risk-based approach and proportionate approach and so on, but they were hanging themselves by saying that in the first place. And I think I made a comment on the previous seminar, because they then prevented themselves enforcing anything. So they've withdrawn that. But my colleague Sam Crouch, who I think is watching this, he's preserved a note of this, and I think we blogged about it on LinkedIn. So
yeah, hi Sam. So what I'm going to do though is I'm going to drop into the chat a PDF. So apparently, and this is totally news to me, there is a thing called the European Data Protection Board.
Yep.
Never heard of it before. Why would I? Why? Maybe you have, maybe you haven't. I've heard of the GDPR. You know, we're an ISO 27001 accredited business, so we take data seriously. I've never heard of the European Data Protection Board. But anyway, they specifically, and I'm pressing enter now, have outputted some frequently asked questions on this topic. And one of the things, Paul, just to sort of add a little bit of a verification to what you're saying there about the ICO said, no, it's cool, carry on using Privacy Shield for a short while. You know, we'll get around to it later on. And that statement disappeared. There is, on the document that I've just put into the chat, there is point 3, is there a grace period? And what do they say? No. There is no grace period. For some reason, I can't see the list or the doc in which you've put into the chat. Can anybody else? Is that just me? I don't know. Maybe. Oh, it's because I put it to the panelists. I'm so sorry, guys. All panelists, all attendees. I'm an idiot. There you go. There goes the list. This is the first one. This is the PDF of the FAQs released by the, what are they called again? European Data Protection Board, and the country list of countries that meet adequacy. I have to get that from here. Just a second. Here it is. There it is. All panelists and attendees. There it is. So this is for you just to look at later on, whatever. But what I'm saying here is, and why I'm putting that in here is that what the guys are saying right now is this is real. This is true. This is right now. And yet one of the things I think somebody mentioned on the last one is, why is this not a national emergency? You've all of a sudden got 3.4 million businesses in the UK, with probably 80% of them breaking the law right now. Why is this not a national emergency? Philip, Paul, is there any, Philip, what's your view on that?
Well, I think it's interesting. In the States, it's business as normal. So I have a letter here that was sent by the Department of Commerce to one of the clients I act for, and it simply says, you do not need to worry about this, just continue trading as normal. Why wouldn't they? The issue is, are people transferring in the United Kingdom personal identifiable information? That's the key thing. And if they are, they have to act now. Well, they need to act now and take precautions. And there are things that they can do to address that. And we will come on to that. But there are two key pieces, well, 3 documents, actually, I would recommend. Yeah.
Okay. Well, look, so we know this. Paul, would you'd agree then that what we know, we are transferring data. We know that we're breaking the law, and we know there's a lot of people that are doing it. Are we safe in numbers, do you think, Paul, or is this just a?
Well, I suppose at the moment, the regulatory authorities have probably got other things which are also occupying them. And over the last weekend, they've had exam board issues occupying as well, which was also a data protection issue, or part of it was. So in a sense, there's safety in numbers in that nobody tomorrow is going to be knocking on your door, but it's illegal. So it's going to, people need to keep a close eye on it, and need to take what action they can take. And there are actions that people can take. Technically, you're supposed to do an assessment yourself individually of the adequacy of exporting data to the United States. Who has the facility to do that?
Where do you even start? Where do you even start? I don't even have a clue. It's crazy. Why is this now our problem? But I get it. I totally get it. But it's like, why is this your problem now? Obviously, I need a little halo above my head right now, which is like, Force 24. We are the solution. Obviously, we're UK based. We don't send any data out to North America. We keep it right here. In fact, it stays within the M25. Not that really matters, but you know, it's what it does. So actually, we're just about to get to the dessert before where we actually talk about what you can do if you do continue to ship data out. But before we do, I was talking to you earlier on, Paul, about this, and I suppose, Paul, this is the point for you. So I'm in a contract, let's say, and I'm in a contract with, I don't know, pick HubSpot. Not picking HubSpot, just inserting a name that you perhaps would recognize. So insert HubSpot here. I'm in a contract with said company. And now I can't use that product because they're based in North America. And all right, they say they've got a European data center, but actually we know that doesn't matter because support professionals can access it from North America, which then means that it's being shipped out on behalf of to North America on behalf of HubSpot, and that's also illegal. So what was my question?
So yeah, what do you do? And
what do you do with your contract? Can you get out of it, or are you stuck with it?
I'd say this. So firstly, if you continue with it for the term of the agreement that you've got, you will probably be okay, but not in sort of legality terms, but probably no one will come out after you. But you should be looking at the exit from that contract unless they do something. And if you want to come out of it because you want to make sure that you're proofing not only your information but the information, crucially, of the data, then you should look at there will be a force majeure clause within your contract. Now,
Force 24 clause, I like it.
Yeah. So if the contract has actually become illegal, then that might be a way of getting out of that contract. So if you want to take proactive steps, then that's where you would start looking.
Okay, thank you, Paul. And Philip, you had an interesting point about the DPA on this.
Well, I would have a data processing agreement in place as well, and I would make sure that there's a clause in there that actually overrides what we call the master contract. And basically, if it's not lawful to process the data, then you can terminate the master contract.
Yeah, so that actually, I think actually a lot of businesses, I think, what is the requirement to have a data processing agreement? Is it 250 employees or something like that?
No, that's a processing agreement. So what we're looking at is a data processing agreement for where we identify who the controller is, who the processor, and we set down the responsibilities of the parties, and that's legally enforceable if something goes wrong.
Yeah. Okay, so what we're saying is that contract in some instances has a clause in it that says if I become in a position where I cannot legally process this data. So those of you out there that have had pretty smart advice on when you GDPR came about and said, look, if this contract ever means that I'm breaking the law, then it should be terminated. So if you did have that, I know that we've got that with a couple of our European partners, but there's no, obviously that's not going to, it's unlikely that would come into force. But the point is that's something that you could look at. So Paul's point was force majeure may be a route out. Philip's point is your DPA may have a clause in there that says you can get out. But I think the most important thing is Paul saying here is not officially, but I think, you're going to be all right but if you renew that contract, knowing what you know now, knowing everything, that you maybe aren't going to be okay. But it's fine to say that we are where we are in a contract. This kind of was thrown on everybody, and it is what it is. But I'm going to now talk.
Adam, can I just add a very small point to that? If people are playing around with processing agreements, it's wise for them to get advice from somebody like Paul or myself. For example, AWS give a processing agreement, data processing agreement. They write that. It's on their website. You can download it if you use their server, but it's written for their benefit, not your benefit.
Bingo. Thank you, Philip. And I'm going to come on to that. So Philip, I know you love this. So I'm going to let you run with this.
It's an awkward question.
No, I know you're going to love this one. So transferring to, whatever. What behind the scenes? Tell me about Max Schrems and tell me about why this got thrown out the league case. And I'm doing this for you now more than the hundreds of people that are watching. I'm doing this for you.
So there was a guy called Edward Snowden, who you may remember is a fugitive from US justice. He's currently held up in Russia. Interestingly, President Trump's looking to give him a pardon, but I suspect that's to help President Trump's campaign rather than for what Snowden did. But what Snowden did was, as I understand it, he was a contractor, and he understood how the US handled data and where it shared it. Facebook featured quite heavily in this in terms of the US authorities extracting intelligence and things from Facebook to use elsewhere. So the consequences of this is that the sort of data champion, who's an Austrian, Maximilian Schrems, we have court case 1, which is to do with Facebook, and then we had the court case earlier this year where he took, because Facebook's registered in Ireland, which is rather convenient, he took Facebook to court. He won the round in Ireland. That then sat and hung around for some time, went off to the European Court of Justice earlier this year during the summer, and the European Court of Justice basically said that Schrems was right, adequacy could never be met, so it struck down the privacy shield, but it also went on to say, which we've missed, it said, and under no circumstances did it think that Facebook could ever meet adequacy. So even if you put in place standard contract clauses, what the court is saying is that Facebook won't meet adequacy, and that potentially opens up a route that other platforms may not meet adequacy either.
Well, I'm going to come on to this actually. So let's now talk about what you can do. Now, it's interesting because I've just seen a question come in about LinkedIn Recruiter, you know, or platforms like LinkedIn and Facebook. Now, you've got to understand that there's a principal difference between me as a consumer saying, I want to put my information in Facebook. I want to put my information in LinkedIn. I am saying, look, I know where, well, somewhere in the reams of terms and conditions, I'm sure it tells me, look, you know, by doing this, you're going to be shipping it out to North America. But I made that choice. Okay, and that was down to me. Whereas individuals that are, you know, you signed up to your mailing list. I've signed up to Bob's Fish and Chip Shop down the road. What was the name of the business that we came up with? I can't remember. Bob's Boxes or something like that. Bob's Boxes. I've signed up because I buy boxes from Bob. He's based in Rotherham. I know Bob, and it's good business. And he makes the decision on my behalf to send my data to China. Is that right? Is that fair? No. It makes the decision to send it over to North America. Same problem. So let's move the conversation on to what you guys should be doing if you are adamant that you cannot get out of these contracts. You cannot find an alternative provider for your marketing automation, your emails, your SMS, your direct mail, all of this kind of stuff. You cannot find a solution. Have to stay there. What can I do? So I'm aware of something called binding corporate rules. So Philip, do you want to take that one?
Yeah, so binding corporate rules was set up for limited companies, typically. So an American company owns a UK business or owns a business in Europe, and you've got problems because the HR department may well be based in the United States, and so the company, the sibling company in the UK wants to share its HR records, and it can't share them at the moment. So to get around that, binding corporate rules were brought out. Both sides sign up to it. It gives protection to all parties involved, including the individuals, with the right legal recourse to law. So that might be civil law, but basically they have the right to bring an action against their company if their data is abused in the States.
So Philip, let's just clarify that quite simply. So BCR, binding corporate rules, is really designed for, like, I'm a business and I've got an office in North America that looks after payroll, and I've got an office in the UK. I've got some staff in the UK, and they're going to be get my data out to North America to process my payroll. So yep. BCR, a binding corporate rule, isn't really, from a marketing point of view, going to cut the mustard.
No,
it's not.
No, it's for internal. I would see it as internal company transfers.
Okay, so what's the alternative? SCC. What's that?
Yes, standard contract clauses.
Okay, so what's a standard contract clause?
So standard contract clause is written by the European Union. It's PDF. Latest edition is 2010. Runs to about 13 or 14 pages. And effectively, the European Union literally dictates what you can do with data, what you can't. All you need to decide is whether you're the importer or the exporter. So obviously, if you're sending it over there, you're the exporter. The importer signs it. Both sign it, and you agree. And it's a legal framework. And what do we mean by legal framework? It simply means that it's enforceable in relevant courts in the UK and elsewhere. And it means, therefore, that data can be safely transferred. And you can't change. The problem is with standard contract clauses, you can't change them. You have to run with the wording, otherwise it's not legally binding. So wow. You either take a very complicated framework that most people probably not heard of until today, let alone actually read, and you've got to go through that, sign it, and it's binding on both parties, or you don't do it. And for a lot of people, that's a big step.
So, Paul, is there anything that you want to add onto this about the process that a business goes through to effectively invoke an SCC, a standard contract clause, about how it works?
Yeah, just very quickly going back onto binding corporate rules, they are hardly used at all. They have to be registered with the EU. There were 2 registered last year.
Wow.
One was Exxon and one was another massive corporation. It's not something an ordinary business will do. So 2 right. Yeah, 3 this year. It's not a common thing. So the standard conditions, they can be used, and the judgment last month said that they are still valid, but you still have to assess the adequacy of the country in which the data is being exported. So you're still coming up against the same brick wall that if it's going to the States, then the government still has access to that data, and therefore so really still ineffective.
It's really a pain in the ass, isn't it? He's like, okay, so what we're saying then in that case is, here's what we need to do. So we need to make sure that we pick on HubSpot again. We've got a standard contract clause that ourselves and HubSpot have agreed to or signed. Do I have to sign them, or is it just they send it to me and I accept? I don't do anything, therefore I've deemed to accepted it. Do I have to sign something?
Yeah, but both parties have to sign it. It actually needs a company stamp on it as well. I hasten whether you could find your company stamp. I think I know where my company stamp is.
Is this 1984? Actually, 1984 this problem wouldn't exist, would it? So no, obviously it's 2020. So you've got to have a whatever. Paul, is there anything that you want to add?
No, I was going to say that this is a company seal, and company seals are not even since 2006 and not even a thing.
That's
anyway.
right. That's absolutely right.
Okay, fine. But then ultimately, once I've done that and I have this agreement in place, these standard contract clauses are in place between myself and, let's say, HubSpot, not picking on HubSpot. I still then need to go to each of my data subjects and say, oh, by the way, I've done this thing with HubSpot and I've done these SCCs. And we're going to be shipping data out to North America. Is that okay with you? I still have to do that, do I? Do I have to ask for their permission? Paul, do you want to go with that one first?
Not under the SCCs. What you should still be doing is assessing whether you as a company assessing whether the country to which the data is being exported has adequate safeguards, and which is why there's problems still with the States. I mean, technically, the other way around it is that you get consent from every customer to the data being hosted in the States. But in practical terms, can that happen?
Well, you know what you asked me? Can I put my data in North America? I'm not a data precious guy. I don't really care. Of course, I really care. My son recently wiped out my ex-wife's bank account by giving his Xbox password out online. I mean, what an idiot. But it was, so I do care about my data, and I do understand that but sometimes I'm a little bit flippant with, like, say, my email address or something like that. But still, if you came to me and specifically said, by the way, we've had a bit of a reshuffle and I am going to now put your data in North America, and I'm asking you because I just think it's a good idea at this stage. I am literally going to say, no, that's not okay. I'm not cool with that. Because why do I have to? Why I don't have to agree to that? I
think there's another point, Adam, as well, that's probably missing from the equation. There'll be quite a number of people on this webinar who will use your platform for marketing purposes. And if you're using other people's data, so you're processing and you're using MailChimp or some other provider, do those data subjects actually know what's happening to their data? No, because the original customer, which could be a retail outlet in the UK, possibly has no idea that data is being processed by a marketing agency through a platform in America.
Yeah, no, it's really
that's never going to meet adequacy.
Yeah, it's really difficult, isn't it? It's such a tricky. Well, I mean, like I say, I just keep pointing to my halo that sits above our head and say, we don't have this problem. Anyway, so I actually think that we're reaching the point where we've covered a lot of the things we wanted to say, and we'll get into the questions. But I think just to very quickly summarise that there are that we as a business in the EU are not. By the way, I've seen in the questions somebody mentioned the GDPR or post Brexit. What happens? I know, Philip, I'm going to point that one over to you because I know that's one you love to run with. But actually, the long and short of it is nothing changes. This problem doesn't go away. So we are now in a position where if we're sending data out to North America, it's down to us, me, you, to figure out, am I opening a can of worms here? And the European Union has written a set of SCC, standard contract clauses, that say, if you agree to do this, this is what you are signing up to. Now, I have been in Force 24 for obviously about 10 or 11 years. and we work with over 4,000 marketeers. And I can tell you, 40% in some way have changed or asked to change a part of the contract based on data. So a lot of the businesses that we've worked with have said, oh, we're not cool with that. We need to see that this, blah, 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 whatever. And we're like, well, okay, fine, no problem. So I'd like to see what happens when these DPOs and these compliance officers that do make these questions to us take these SCCs and say, whoa, we're not signing that. Have you seen that? It says that if this happens, then we're liable for 50 million quid or whatever it is. So I'm just going to, you can't change these SCCs. They are what they are. And if you change them, they are no longer binding. Is that right? They're just a worthless piece of paper at that point. Okay, cool. Right. So let's oh, what's the worst that could happen, Philip?
What's the worst that could happen? You could have a 4% fine of your worldwide turnover.
So back to the old GDPR, 4%.
Yeah, absolutely. So it's considered the worst offence that you can commit. So it's the most severe offence. That's why it's a 4%.
Oh, I can think of worse offences, Philip. Come on.
In the data protection world, it's a big no-no.
Okay, fair play. All right, okay, guys. Look, Paul, is there anything that you want to say that you don't feel that we've adequately represented or covered from your point of view at this stage? Or Sam, you're probably listening, saying you should have said that. You should have said. But
I'll give you one thing, which was sort of just interesting, but it was something that actually Sam picked up. So he queried what Stripe were doing with his data, and they said it's fine. We know about Privacy Shield, so we're going to rely on the Swiss-US Privacy Shield. Ah,
yes, we've heard about this.
So, however, the Swiss-US Privacy Shield is exactly the same as the EU-US Privacy Shield. It's pure cut and paste, and so it's not. So it's as if they're going to divert the data through there. So we've all heard of money laundering. This sounds like data laundering. Also not legitimate.
Okay, so that's only got a limited shelf life, is what we're saying. It's like, yeah, okay, you could probably get around that for a short while, but
rules as a Swiss cheese, I would say.
Fine. So if you're about to enter into a 5-year contract with HubSpot on the basis of a piece of Swiss cheese, it's maybe not the smartest thing to do. HubSpot again. Sorry, I don't mean to keep talking about them. Take that out of there. Very good company, great product, and no issues with them whatsoever. Just mentioning the name. Okay, so Philip, is there anything that you feel like we haven't talked about, that you'd like to address before we dive into the questions?
No, I think somebody posed a question to me about, could I elaborate on something on framework or legal framework? And I think what I was alluding to lead up to say was that there's two issues here that you can enforce it. So there is sometimes a breach of criminal law, and there's sometimes a breach of civil law. And therefore, in terms of a legal framework, quite often with these agreements where they're based overseas, we're talking about civil law, where people can go off and sue an individual or sue a company and claim compensation for a data breach. That's outside the EU.
Well, there was that guy Morrison's, wasn't there, you told us about last time?
The Morrison's guy is an interesting case. So he decided to out all the company records of current and past employees. He committed an offence under the old Data Protection Act and went to prison, I believe, as a consequence. I'm not sure if he's still in Armley Jail, but if not, his time must be coming up shortly. But in the meantime, a class action was brought by the ex-employees and employees of Morrison's, who all claimed damages. It went to the High Court and it was upheld. Morrison's appealed against it and the Court of Appeal have struck it down. Now, where that goes from there, I don't know. But if you think that we're talking roughly probably 200,000 people affected and they all got £1,000 compensation, that's a lot of money for Morrison's to put out.
Okay, right, brilliant. Thank you very much. Let's go through some of the questions. Now, what I've noticed is that there's common themes. So rather than, I'll ask the questions and credit the person that's asked. But I if I see the same question, we'll not skip it, but Okay, so do you know how, this is from Joe Willis. Thank you. This is one of the first questions. And I know that we've got the chat questions and we've got the Q&A questions, so I'm just trying to merge it all together. Do you know how the major IT service providers are dealing with this? e.g. AWS, Salesforce, MS Dynamics, etc. Yeah. And the point here, Joe, I think this question is going to come up time and time again, and a lot of people have said this, but it's the same answer. The fact is they don't have any choice in how this is being dealt with, and actually they are not liable. So from what the guys have been telling us, it's okay. You've got standard contract clauses, which you have no say in, you just accept. You have their assurance that the data is stored on a European server. Now, let's pull into that point because actually, let me find, where is it? Morning, Paradise. Does Brexit? No, want to talk about at the moment. I can't see. There's one chap that says, I can't remember. Sarah, is it? No. Okay, somebody else asks the question. So what if, okay, I've got the data in North America. Sorry, if the support function is based in North America, so I'm storing the data in Switzerland or France or whatever it might be, Amsterdam, Dublin. I'm storing the data in an EU place on behalf of Microsoft. Let's stop picking on HubSpot. Storing the data in Microsoft. But Microsoft have a support function in India. They have a support function in North America. How does that work? Philip, do you want to go with that one first?
Well, Microsoft, in fairness and credit to them, they've actually tried to split up the business as best they can. So they have a server, Southern England, which is designed to look after England. But the problem you've still got is that the US side could be mandated by the federal government to access data. And of course, that can happen. So there are limitations in terms of what can be done. I mean, I'm advising a platform that provides certain services in North America. And I'm saying to them, we do the audit, we go through, we try and make sure that they're meeting adequacy, but there's no legal framework that they have to agree to or operate to, other than they did sign the Privacy Shield, which has now been struck down, and we can offer anybody who complains standard contract clauses. Beyond there, that's it.
So actually there, what we're saying is that's almost one step worse, isn't it? Because there's a difference between me collecting your data and saying I'm going to store it in, the EU. I tell my data subjects, no, it's cool, because we're going to store it in an EU data center. That's cool. And I now store it in there. I'm being super compliant. But then the company I'm storing with decides, no, I can't support you from the UK. I have to support you from North America or India. So therefore, in order for that support to happen, they physically have to transfer the data to their physical location. And that's how it works. It doesn't mean wholesale ship your entire database. What it means is that they will access it from that location, which is the same as shipping. So what you've done there is you said, no, it's cool, Mr. Customer. I'm sending it into the EU. It's not a problem. But where I've sent it has then moved on. So, but I'm still liable. I'm still in the middle. And I'm the one that's going to get, in the event of a breach, that guy does the Morrisons on me. I'm liable, and that's ugly. But that's not good. Okay, so one of the questions actually from Philip is Philip LV. I don't know if I'm saying that right or not. Morning, can you ask the panelists, does Brexit render the ECJ judgment irrelevant once we finish the transition period? This would just assume that we're sending the UK citizen data to a US platform. So how's Brexit going to affect this? Philip, do you want to go with that? And then
all right, fine. So Brexit doesn't really affect it. So we might argue with Europe about all sorts of things in terms of that final settlement. But in effect, we have given a commitment that we will continue with GDPR. That will be incorporated into domestic law. The plan is it will become UK GDPR. And we all know what that means. It's likely that we'll end up with, even though the government's claiming it won't, we'll end up with additional clauses. So if anything, it upholds the framework of that legal agreement and strengthens it. So Brexit won't make a scrap of difference.
Okay, and Lindsay, you said once the UK has fully left the EU, will the EU data subjects transition to UK data subjects, or does it still be? And I think the point now I can quickly answer is the fact that the UK will deem the EU as being adequate. So it isn't the fact that yes, we only care about then our EU, but then if I've got EU citizen data as well, and it doesn't mean I can ship that out. It means that I've got two sets of rules. I've got the UK GDPR. Is that right, Philip? The UK GDPR?
So UK GDPR, that's the plan. I mean, this is not all finalised yet. And then the sort of converse of that is that we will have to meet adequacy and satisfy the Commission in terms that we meet adequacy. But it's, to be perfectly honest, I don't see it going to be too torturous. I just suspect it's linked in with the whole trade negotiations that are going on at the moment, and the EU aren't going to relent on that until everything else has been agreed.
Okay, cool. So what we're saying there is, forget Brexit. It makes no difference to whether it's UK,
Correct.
EU. Your same things are going to still apply. Everything's going to be. Is there a legal precedence on DPAs overriding the master terms and conditions? Oh, I don't know. Let's ask Paul that one. Could a DPA actually override master terms and conditions?
The short answer will be no, I think, because standard terms and conditions can't be amended, so they can't be amended by another agreement amending them. They then wouldn't be validly binding standard terms and conditions. So no, I don't think so.
But playing into your point,
I would just venture it would depend how both agreements have been worded. I would suggest
if they're in tandem.
There may be times. It depends. So you may actually have anyway within the master agreement certain conditions, because if you can't perform, because what normally happens in the master agreement is as if this clause is no longer valid, the remaining content remains valid throughout. But of course, if you can't legally, if you're in a situation where effectively you can't legally perform a task, then is it a valid agreement? I suspect the courts, it's not been tested, all this stuff, so some money to be made here, Paul, but I suspect it'll probably get struck down by a court.
Okay, so next one, Lindsay and Vicky, you've been pretty, right, okay, so Vicky, you've then said platforms such as Facebook and everything meet adequacy, but what don't meet adequacy, but what about consent of the individual? Yeah, we've covered that, yeah, we absolutely agree. You know, what I do as a consumer with my data, if I want to sign up to a website, you know, of a specialist company in North America, I think, oh, they sell cool desks. I don't know, random thing. They sell cool desks. I want to join their mailing list. That's fine, because I made that choice. That's me dealing with a North American business as a EU consumer. That's fine. Actually, what I've seen recently is really annoying. Is there's a couple of used car websites in North America that won't let you on because they detect I'm from the EU, and they say, do you know what? We're not interested in this. We're just staying out of this. So I have to then go through a proxy in North America to then just see this used cars website's inventory. It's like, God, how far do you want to go? I mean, but you know, the point is, it's my choice overrides the adequacy. So I'm not going to stop using Facebook or Instagram because I'm just working on the basis that everybody uses it. But it's different for me giving you my data and you deciding what to do with it. Okay. Can you provide a link of the SEC for 2010? So Vicky asks, Philip, you mentioned that the standard contract clauses. Where are they? Where can I get a copy?
I'll send you a copy and then you can pass it around.
Okay, so Sam Duggan.
We'll upload it to a cloud.
We'll upload it into a cloud. Yeah, so Sam Duggan, can you make a note, please, that on the follow-up email when we send out the recording, can you make sure that you put a link to where we can find the standard contract clauses? Hi, if you have an agreement where the data is, so this is from Sarah. Hi, if you have an agreement where data is stored in the EEA, but it's help desk support, this is the one I was trying to find earlier on. So if the data is in the EEA, which actually is the EU, I think it's from a data.
No, it's a wider remit.
Okay. So if the data is here, but support is elsewhere, we've covered this. We've said that actually you've got to make that call. You've got to make that call. Are you doing something that is legal or illegal in the point of investigation? And they said, well, no, the support is based in wherever. You'd say, yeah, well, we did know that, but we just deemed that as a risk that we were prepared to accept, I'm guessing, when we signed the SECs anyway. Is that right, Paul?
Yeah, I think so. but it's something which you could push back on, and I suspect that companies that have support in the States or in India and so on are going to get pushed back on, and we'll have to address it provisionally.
Yeah, but I mean, the pushback is going to be move your support department, and I can't see Microsoft saying, yeah, cool, I'll get that sorted, not a problem. It's done. No, it takes time, and this is a transition.
Yeah, but some of them, like, as Philip said, some of them like Microsoft actually have made those moves.
Yes, yeah.
They've had, Microsoft, particularly, and Google more recently, have had some very, very bruising encounters with the EU, which they can do without. And so big corporations will still do things. Fines under even Google would not like a 4% of global turnover fine.
No, that's true.
I'm going to struggle with this one. Misra. I'm terrible at reading at the best of times, but anyway, Megna, I apologize if I've said that totally wrong, and I know I will have done. Why are SCCs not widely used? Is it due to the cost and the complexity? And what do companies have to do if they wish to wish to do business/transfer data with 2 countries outside of the adequacy circle? So just a quick one on that one from my 10th penneth. You didn't have to 2 weeks ago, because Privacy Shield handled that for you in North America, whereas that's gone now. So that umbrella that you've been sat under has gone. They've taken it away. It's raining directly on your head. So you've got to get your own little hat on, and those hats are the SECs. And yes, it is down to you to form an opinion on the adequacy of what you're doing. Philip, you want to add something to that?
Well, I mean, data protection officers know about standard contract clauses. They don't particularly like them, but they would know. But it's a geek's world. It's not something you're going to take to bed and read before you go to sleep, unless I suppose you suffer insomnia. It's a legalistic, very boring document. So I'm not surprised that people don't know about them. But the fact of it is, people are going to have to know about them. As I say, you can set them up, you can sign them, but unless, again, you've got a bit of legal guidance, you may not actually understand what you're signing and what you're agreeing to. And the other party in North America, or as you call it, or the United States, we should say really, it may well be that they sign them at the other end and they don't know what they're signing up to either. I mean, we've got to have adequate protection of the data and put in appropriate safeguards and measures.
It is crazy. It is crazy. So Jenny has asked, so our mailing list sits on MailChimp. If we simply download those, delete this list and close the account, well, then you've got the other problem. You're creating duplicates. This is the thing. So your point, Jenny, and this is, look, you don't download it and delete it. You just delete it, close the account, move on. Yes, UK platforms exist. Force 24. And there are actually quite a few. So, I mean, I'm picking out, obviously, Force 24. I'm not going to give you the names of all the UK ones because this is our party. And, it's my choice. But the point is that there are UK platforms and they're bloody good. We compete against North American platforms all day, every day. And we've got a win rate higher than theirs, much higher because it's just better. So Jenny, the point is, what you're saying is you'd physically download it. Remember, data's not a physical thing. Only download it if you have to download it. Don't download it, create a version on your laptop, then email it somewhere, which creates a version in your outbox, which creates an inbox version there. Because that was the whole point of the GDPR ages ago. It was like, what are you doing with your data? Because if somebody says, I want to be deleted, you've got to go through each of those stages and you've got to delete them. It's a nightmare. So let alone add standard contract clauses into your mix. Platforms like ours are designed around UK and European law to make your job easier. This is we exist to mean that you ask us that question, we just show you what to do. Anyway, how do small companies manage this who rely on cloud providers free? I think we've gone through this. How do small companies handle this? We're using MailChimp because it's free. You know what? Any company that ever came to me and said, you know what, I'm going to email you through this North American platform because it's free, I'd say, do you know what? What you sell me isn't free. So I actually want you to be a bit more careful about how you handle my data. And that's the reality of the position. It's like, yeah, it might well be free, but you know, you've got to make that choice. You've got to go with those SECs, and you've got to say, this is what we're going to do, and just, I'm cool with it.
Well, of course, one of the things, Adam, that you've not touched on is that people may start, or companies or individuals may start blocking the IP addresses of stuff coming from the States simply because of the adequacy issue. And that would be a nightmare for their delivery. I can see that happening.
Oh, God, yeah. Yeah, that's a good point. That's a very good point, yeah. So actually, you're right. The mail servers, they may say, you know what, I'm going to start blocking delivery from United States because we don't believe that we want to, maybe, who knows? That's speculative, obviously. Nobody knows. So from Scott Anstey to all parents, given the Patriots Act, oh, I love this, starts with the Patriots Act, it must be a man after my own heart. If we agree to the SEC with a US company, is it worth anything? No, I don't think it is. And this is what I keep harping on about. It's like the Patriots Act says, forget it. We're looking at your data, whatever flipping clauses you've got. We're looking at. I'm getting a bit over the top here, but okay. So it then goes on to say, is it worth it? If it isn't, how do we agree adequacy, safety of data if it's in the USA? Or do we just ask people to agree or not to agree? Yeah, that's your point. You've got to either now start putting in your privacy documents or the disclaimer you use on the bottom of your form, is it cool? We send it out to North America. Or you've got to wait for said provider to deploy into the European Union a fully managed business unit, which includes servers, which includes support, which includes perhaps billing, which includes everything to do with running your account should be in the EU. And at that point, you say, it's cool to use insert MailChimp here. You know, and that's the point when it's, you know, it's totally safe. But I think what you're saying is, and guys, correct me if I'm wrong, storing data in North America is going to be problematic moving forwards. Paul, do you agree with that?
Well, effectively, it's illegal from now, or legal from the 16th of July. So people need to be taking action on that, and if it's either moving services to UK, EU-based providers, or those providers who are in the States having a complete set of infrastructure in the EU, one of those things is going to have to happen. So there's going to be something will happen quickly. It's going to have to happen quickly.
So one of the things, Adam, that needs to be done, I think, if people continue using things like MailChimp, is that they're actually going to have to update the privacy policy to actually put that the stuff goes across to the States. And technically, if you update your privacy policy and you've not included MailChimp in the past because you've relied on the Privacy Shield, you then ought to notify all the data subjects that you've actually changed your privacy policy. So there's quite a bit of admin there.
I remember when everybody said, and again, you know, on that point, okay. So Paul, there's probably a question for you, because I know on GDPR it was a difficult one. I'm going to notify all of my subjects about my new permissions. Right, okay. So this was GDPR 2-3, how long ago was GDPR now? 2 years?
2018.
Yeah, so it was like, right, I'm going to have to send an email to everybody in my mailing list and say, look, these are my new permissions. Do you accept them? And of course, what happened was people just killed their database overnight. It was like, oh God, we had 100,000 people. Now we've got 6 people because they're the only ones that clicked on the yes, I accept. Now, Paul, my question to you would be, okay, let's imagine I'm going to say, no, screw all of this. I'm just going to say to my audience, I'm going to store your data in North America. Do they have to accept, yes, it's cool, or would the notification itself serve to be strong enough?
They would. Well, they would. It depends on the nature of the data, but in principle, they would need to consent. And if the data is particularly personal data, particularly sensitive data, then the consent has to be really detailed. So it's not an easy thing, as you say. It would kill databases. People marketing databases will just collapse. Yeah.
Okay. Neil's come up with an interesting point. How about importing American data? Whoa. Well, actually, that's fine, I believe. Really? I think, unless it's from California, and then Californian citizen data, we have to meet their adequacy, which I don't know whether we do or not. Maybe.
California is kind of leading the way. I haven't seen in detail what they're doing, but they're kind of leading the way in the States on adopting as close as they can get to a European model. But there still is the overriding Patriot Act and all that kind of stuff.
Yeah. Okay, so a lot of people now asking the question is like, should we be considering moving our infrastructure over to the UK? Should we be doing this? And I think generally, you know, that we don't have to answer those questions specifically. I think what we're saying here is obviously we're sat here as a UK tech provider saying, hey, why even entertain this when you should at least check this out? It'll be cheaper, it'll be faster, it'll be more supportive and better. It'll be all of these things, so you should use it. And the same, you know, all right, we don't provide IT infrastructure, and neither does Philip, and neither does Paul. You know, the North American giants have created the world in which we live in, the Amazons, the eBays, exactly all of these things. But it's just pick the battles that you need to pick, I think is the point. You know, you're going to have to eventually deal with all of these things. And the easy ones, there is no UK eBay. Well, there's eBay UK, but the point is, it's like, if you are relying on eBay, you can't take your world off eBay and just start using some Schmeebay or something like that. You've got to, but then eBay actually is totally different. So don't take eBay as being an issue. But the point is that what I'm saying is like, you've got to pick your battles, and where there is easy wins, you definitely have to take them, because as Paul mentioned earlier on, you know, the fact is there is no transition, there is no grace period. And actually, if you have knowingly just lapsed or carried on or whatever, then I think that's when you've got a problem. So you've got to pick these battles one by one. Right, so the difference that the EU people have absolutely no readdress in the USA. Oh, Sam, is this some, do you know what, Sam, you've put some great points in here. Stripe have responded to you, blimey heck. There's some great points in Sam. What I'm going to do is I'm going to ask Sam to take these notes and put them all into a page, and we'll send an email out with the recording with our panelists' responses to those questions. And I think just having a quick flick through now, how long does it take to get an SEC approved by the EU from Harry? Harry, I think the point is you don't get it approved because it is standard. The whole point is it's standard. You don't get it approved, you just do it and you say, right, well, I'm just going to take it on board. I think the rest of the questions, what we're going to do, I think, because conscious of everybody's day and time, we've reached probably a limit. We're gonna flick back through these questions and we'll put them back onto a web page, and you'll be able to see the answers that the guys have given specifically to these questions. So I think we're going to call it a day there. I am literally wet through from sweat. This has been such a passionate argument, debate. I really enjoyed it. And I'd like to thank you, Philip and Paul. You've done an absolutely fantastic job. And thank you for your time, guys. And if anybody needs, look at the signs behind Paul. Specialists for digital business. There you go. And there's the web address, Berwins, what? I can't read that. berwinsdigital.com. Yeah. There you go, berwinsdigital.com. Anybody needs any support, please speak to Paul. Philip from Allett and Associates, the Force 24 DPO. We appointed Philip several years ago to help us act as a DPO. And Philip, what's your web address? allettandassociates.co.
Yeah, take my email address and just put www. at the front of it.
Where's your email address, Philip?
On my name, I think. Oh, right.
Is it?
So it's www.allett, and associates.co.uk.
Yeah, and we're force24.com. Anybody wants to go and talk to Philip, please reach out. Go to Allett and Associates. Anybody wants to talk to Paul, please reach out and go to Berwins. Anybody wants to talk to us, please come to force24.com, download our price list, book a demo, whatever you want to do. Thank you so much, everybody, for your time. Lovely to chat with you, and we'll see you all again. Take care, guys. Bye-bye.
Thank you.